Hello everyone, my name is Nguyen from Aussizz Group in Perth, and today I'd like to discuss with you about the AAT, the Administrative Appeals Tribunal. Specifically for international students studying in Australia, you need to be aware of this, about your rights, merits review rights, if you ever come across this particular situation where you've received immigration notification from your email to notify you that either they've refused your visa application or they've even cancelled your student visa. So what to do? Just to summarise in short initially, if you ever receive this notification from immigration, you do need to know that you have merits review rights. Because you are onshore in Australia, your rights are protected by law. You have the right to apply to the Administrative Appeals Tribunal for a merits review of the immigration decision that's made against you. Before I go further to talk about the actual AAT process, I just want to give you some details of how would you end up receiving the immigration refusal notification. Okay, so in certain circumstances, like if you are studying currently and then sometimes during the course of your study, you may have been delayed in finishing your course before your student visa expires, and so you needed to have to extend your student visa. In that case, when you apply for a visa extension, you would normally wait a few months, a couple of months for immigration to come back to preferably grant you the student visa, the extension, so that you can be able to finish your course study. Now, if it comes to a situation where within a few months, instead of a visa grant that you're waiting for, you received a notification from IMI to say that they have refused your student visa application for an extension. And in this situation, I'm sure that anybody who receives this notification will be quite stressed and anxious to know what are their rights, what should they do, and why has it come about like this. In general, most of the time it would be because of genuineness, the GT component of the application for your student visa. When you applied for a student visa, you still have to continue to satisfy immigration that you are still a genuine student. So when they come back with the refusal of your student visa application, they would have detailed notes, or they would state in detail the reasons why they have refused your student visa application, and the main gist of it would be based upon GTE. Okay, so with that, it's the clause 500.212 of the Schedule 2 of the Migration Regulations, and usually it's because either you have sought your student visa extension because either you have failed certain units, and if also that have perhaps that you changed course. So when you first came over to Australia, you had a package that you were enrolled in to study certain courses. If you ever moved away from those courses that you had initially enrolled in and you studied a different course, now later on when you try to extend your student visa and you try to convince the case officer that you want to continue to study this new course that you have enrolled yourself as opposed to the old course, well, it will come into consideration with the immigration case officer whether they think that the new course that you're studying does also meet the requirements, that you are still maintaining the genuineness of you being an international student. Okay, so all in all, what I'm trying to say is, if you do get immigration refusal notice, it would mean that you have within 21 days to apply to AAT, the Administrative Appeals Tribunal. If you miss out on applying within the 21 days for AAT merits review, then you miss out completely. You will not have a second chance to apply to the AAT, which means that over time, in a very short period of time, when your bridging visa A expires, right, you will be illegal in Australia, and literally you have to go home. So please don't take it lightly. Once you receive immigration refusal notice, you must either decide immediately or go and contact agencies like ourselves, Aussizz Group. Come and see us. We're very friendly, and we'll be able to help you, myself personally. Okay. Now, not just visa refusal applications, like if you apply for a visa extension or applying for any visas as such onshore, and if you received a visa immigration refusal notification, then of course you have within 21 days to apply for AAT. That's also like once you've graduated from your course, and then naturally you applied for the temporary graduate visa, and so you wait about a couple of months, and then they come back, and you are waiting to be granted the graduate visa subclass 485, so that you can go on and be able to work full time from 18 months to 2 years normally. But instead of receiving the grant itself, you received immigration refusal notification for the application for the graduate visa. And so that will be a shock too, because you think that it will be a normal process, nothing toward that you could think of initially that you would have done something wrong for you now to receive this refusal notification. For the 485 visa subclass, for the temporary graduate visa application, it could be that you've provided wrong documents. So for instance, AFP, Australian Federal Police Check, instead of uploading the Australian Federal Police complete disclosure, you uploaded a standard disclosure document. So with that, it's enough for them to refuse your 485 visa application. Simple as that. Or else you've clicked onto the graduate post-study work stream rather than the graduate work stream. Okay, so there's little things that could have failed you in a sense, that you've done an invalid application to the extent that within a couple of months later, immigration will come back with the immigration refusal of your visa application. So that's talking about visa refusals. Yeah. What if while you're studying, and then one day you received an email from your from immigration, and it shows on the title as NOICC. So NOICC is notice of intention to consider to cancel your student visa. So currently you're studying, you're holding still, I suppose, because they haven't cancelled yet. They've given you a notice. It's called NOICC, notice of intention to consider to cancel. So when you receive this email, they will give you within 5 working days to explain to the case officer of immigration why they should not cancel your student visa. Okay, and how and why would they, send this notice to you? It would have been most probably because you do not currently hold a CUE, because along the way somehow you've got a CUE cancelled for whatever reason, or even you've breached a student visa condition from your visa. And so if it triggers immigration, if they find out that is the case, they have every right to then, before they cancel your student visa, they must give you notice. And that's why you would, of course, receive a notice first, and that would be the NOICC. So you have 5 working days, within 5 working days, to email back to them a submission or an explanation as to why. So some people have, if they could find a way to, if they've lost a CUE, they need to go and find and pay for a deposit to get the CUE, a new CUE from a course, and then supply that or attach that evidence, a CUE, with the submission to try to explain the case to the immigration officer. Now, so once they do that, and then they wait. They may wait for a couple of weeks, up to a few months, depending on how long immigration will come back to them. It's not a given that they will immigration will return, make a decision immediately. But once they do, there's a higher chance, that's more than likely, that once immigration has already sent you an NOICC, there's very, very little chance that you could be able to be successful. There are certain circumstances, of course, where we have been successful for the client, that we've made submission, we explained the situation to immigration of the compelling, compassionate grounds, the reasons why the student lost the CUE, and they're in the process of continuing with their studies. So it's a very detailed matter, a very detailed submission that we provide to immigration. Sometimes we win for the client, so it's not a given. But after you've provided submission, sooner or later you'll receive another, notification from immigration. If you've been successful, they'll leave you alone. They'll notify you that that's that. They will not pursue this matter any further. If you're not successful after that, then of course the next step would be, the next notification would be they've cancelled your student visa. And they would clearly state in their decision record the reasons why they cancelled your student visa. With that, still, you can still apply for the AAT, the merits review, because you're onshore, your rights are protected still. Instead of within 21 days to apply to the AAT, now you've only got 7 working days to apply to the AAT. Okay, so as long as you do that within the 7 working days, you are literally saved or safe in a sense that immigration will practically leave you alone. Because once you've lodged the application for the merits review at the AAT, then the actual Administrative Appeals Tribunal will take over your matter. And with that, immigration will just leave it at that. They will not pursue any further. Okay, so you are with the AAT now, which means that only when the tribunal opens your application, and this could take a year and a half, 2 years, depending on how backlogged the AAT, the tribunal, is in terms of so many applications going through to them, that if they haven't got a chance to reach your application, then it could be delayed up to a year and a half, 2 years, depending. So when they do open your application, the first step that they will do is to seek further information from you initially. So they will send you an email to seek that you submit, they invite you to submit some more information for them, so that if this first step is a preliminary step, that if you do provide relevant information to back up the reasons why you decide to seek a merits review from them, and if they can make a decision on your behalf in your favour at that time, at the initial stage, then there's no necessity for you to pursue further with going to the AAT hearing, which is a day at the tribunal. Okay, but so it could be that after receiving further information from you, then the AAT can advise you further that they could make a favourable decision. Then they would make it there and then. But if even after receiving further information from you, and they've not emailed you back, the next step is they will come back with a scheduled AAT hearing. So they will schedule a hearing for you to come and see them at the tribunal, and that's when you will get to have a day in court as such. You will get to speak directly to the member at the AAT hearing. The member will be speaking to you directly, asking questions, and you answer to the member directly. So this will be a chance for you to provide more documentations if you have any more, but also it's a chance for you to provide your personal circumstances verbally to them, to try to convince them that you are still a genuine student, that you have every intention to stay here temporarily in Australia, that you do meet the requirements of a student visa, and that was the reasons why you wanted to appeal to the AAT, because you did not agree with the immigration's decision to refuse your visa application or even to cancel your student visa. Okay, so let me say that for you to understand, the AAT itself is independent from immigration, in a sense that they have the full authority, if they believe in your story, if you are convincing to them, basing upon compelling, compassionate grounds, if they see that there are reasons to argue against immigration's decision, they will have the full authority to make a decision to either, to remit the application back to immigration for reconsideration. They either can affirm immigration's decision, which means that they believed in immigration's decision, which means that you have lost your fight at the AAT, or else they can remit back to immigration for them to reconsider, which means you've won at the AAT because they believed in your story. Okay, so there's a few ways that the AAT can perform in their duties to act to oversee or look into your file or your application for merits review. Okay, now the fees have increased. So recently, from the 1st of July, but it's less than 1,800 for AAT application. Ultimately, it's a chance for you, if you believe that you don't agree with the decision that you've received from immigration, and also if you need to buy more time to stay onshore for whatever purpose that you need for your skilled migration, or that you're not ready to go home yet, or if you really want to fight your way and try to win at the AAT, then for sure you must remember that you need to apply within the time frame that is stipulated within the immigration refusal notification or the immigration cancellation notification. Okay. So whenever you receive these kind of emails from immigration, please do reach out to Aussizz Group, to our migration agents here, to me, if you like me and you'd like to see me, then I welcome you to see me, and we have a consultation where I'll sit down and explain to you in detail how the procedure goes. Okay, it's pretty straightforward, and I would explain to you that literally it's applying, and then once you get invitation to go to a hearing, we will prepare you to go to a hearing, and we will find every possible way to try to help you to win at the AAT. Okay, and so we're quite experienced in what we do here at Aussizz Group. So if you have any doubt, any worries, please come and see us at Aussizz Group in Perth, and if you're anywhere in other states, Melbourne, Sydney, Brisbane, Adelaide, then please reach out to us at Aussizz Group, and we're here to help you. Okay, so if you have any questions, please do inbox us or email to me. My details will be provided, and I'm here to help you at any time.
May, there are few questions here that's not related to AAT though. Right. It's about 485 visa. Would you be able to answer it?
I'll try, yes.
Okay. It's from Malin Devaka. He's asking, this is about 485 visa. Is there any rule about applying for the 485 visa within 45 days of final result released?
Right. All I can say for this question is you need to know that once you have completed your course, let's say you completed a course at university or even at the vocational education sector, the completion letter would clearly state the date of commencement of your course and the completion date of your course. So we use the completion date. From that date, you have 6 months, within 6 months to apply for your graduate visa. If you go over that date of 6 months, then you would lose the chance to apply for your graduate visa. Okay?
Okay, there's one question that's related to the AAT. Vanessa May, she's asking, what are the possibilities of refusing again?
Ooh, refusing again. I don't understand.
She just left it at that.
Okay. It could be that, let's say, you received an immigration refusal notice, then within the 21 days or whatever days, usually 21 days, you apply for the AAT, so the merits review at the AAT. Now, if we go to the AAT, if we don't win at the AAT, you were not successful at the AAT because the AAT member of the tribunal affirmed immigration's decision to refuse your visa application. There is one more chance for you to pursue merits review, and that's at the FCC, the Federal Circuit Court. So you have within another 35 days from the decision of the AAT to apply to the Federal Court, which is called the FCC for short. So you can still pursue that if you've got you didn't win at the AAT. Okay? Yeah, I hope that would answer your question.
Okay, another question is from Damien. He's asking, my wife's 485 visa expires in March 2020. We were advised to move to Tasmania and for her to study a diploma level course. What steps do we take if this visa is refused? Isn't it quite obvious that this option is done just for prolonging this to get the PR? Please advise.
So can you read that again? I'm sorry.
So his wife is on 485 visa,
yes,
which is expiring on 2020.
Sure.
So they were advised, probably by some migration agent, to move to Tasmania and to study diploma level course.
Okay.
So his question is like, isn't it quite obvious to the immigration that they are just they're just enrolling in the diploma and course and then applying for student visa just for PR reason? And then he's asking, what if the student visa gets refused, what he needs to do?
Okay. So it's a bit layered question, but let me just break it down for you. I understand that your wife's visa is expiring in March next year. So if you move to Tasmania and start studying, of course by March she would not have finished her diploma to meet the requirements to pursue for later on for other skilled migration visas, like probably the 489 or 491 or whatever that you're trying to pursue. So of course you know that you need to extend your stay in Australia to be onshore. So the next potential visa that's applicable to you that you're eligible to apply for would be the student visa. Now you're saying that there may be some high risk that what if immigration refused the student visa application that you would apply before the March 2020 expiry date of the 485 visa. So if that comes along and they refuse, and the reason why they would refuse could be based upon GTE, that they may not consider that she's a genuine applicant, and they may have a suspicion that she's using the student visa to extend or prolong her residence in Australia because she studied in Australia already, she'd gone on to the 485, and now why doesn't she go home? But she wants to continue to further her stay in Australia. And so potentially they may refuse the student visa application. So if that happens, then yes, then naturally she has still the rights to appeal, and that would buy her more time in Australia. So in a sense, if you're saying that, but then every application is considered upon its own merits, okay? If she can show proof of the relevance of her study, even in Tasmania, even of a diploma, even if she did a master's course and then now she decided to study 1 year, and you were advised that you need to study like a 1 year course and you chose to study a diploma course, fine. If you can, in this new application, because once you've gone through the education system in terms of holding a student visa ready, then you moved on to 485 visa, it would seem that your slate has wiped clean, that when you apply for a new student visa, it should be fresh, right? Even though the history would have shown that she's already studied whatever, and then she applied for a graduate visa, and now she wants to continue to study. She studies something. Now again, every fresh new student visa application should be seen as a fresh application. So long as you prove the genuineness of that visa application, you would be granted a student visa. Or else, what is the point in allowing potentially for a graduate, people on a graduate visa, and then still allowing people to also study again if they want to? If you win, if you are convincing enough by the point of being a genuine applicant for this student visa application, then there should be no problems with you gaining the student visa again. So my aim to tell you is that so long as the GTE component for this new student visa application should be really strong, and try to be convincing that this particular diploma is going to benefit her, your wife, when she finishes, as she goes home. Because there should be no mention of the reason why you want to study this course so that you can stay longer and try to find skilled migration. It should be mainly purely with the whole essence of the meaning that she chose this course of study because she believes that this course would be still relevant to her previous course of study, or else it would help her to boost her career options, employability when she returns home. Okay?
I've got a compliment for you from Mitos. I think it's your existing client, maybe. Thanks, May. You have been my stress tablet during my hearing last week. Hoping for a positive decision from the AAT.
Yes.
I would recommend to approach May if you are having trouble in deciding what to do when refused visa.
Oh my gosh. Thank you so much for your kind comments. Yes, we're still waiting for the decision from the AAT. We did go to the hearing last week, but...
Was this about student visa refusal?
Yes.
Okay.
Yeah. But we feel that hopefully, fingers crossed, it will come through.
Okay. Next question is about partner visa. She's asking Amandeep Singh, hi, can you please tell me my options? My husband is waiting for 801, 820 for last 3 years. No progress has happened, just extra documents to support my application which I have submitted. Last conversation with the department was that they said They are considering 801 straight.
Okay, so this, if I can give you something to relieve your anxiety, we once in a while we have some clients who are in this position as well, so you are not the only one. Of course, everybody's circumstances are different. I do strongly recommend you come and see me so that we can go through the file for you, and I can pick out certain points that would pop up, the reasons why you've been waiting so long like this. But it's not a norm, but it's not like something that you should be so worried about. We need to know the full details before I can give you a clear answer for you. Okay, so please do come and see me or email to me the immigration notifications. I can read through for you and I can explain for you further. Okay.
Amandeep, if you're from Perth, just call us. Our contact number is in the description. If you're from other state, then you can contact the Aussizz group offices from the other states as well. Another question is from Riaz Ahmed. Hi, I'm on 485 visa and I have to apply for my partner visa. Do I have to have a certain period of time left on my visa?
Okay, all I can say to that question is you guys should know that to be eligible to apply for any substantive visa, you must currently hold yourself a substantive visa. So for whatever reason, if you are holding just a bridging visa A, that is not a substantive visa, then you're not eligible to apply for another substantive visa, like a partner visa or any other visa. Okay, so please bear that in mind. Now, if you're talking about partner visa, you must hold a substantive visa, any substantive visa, for you to be eligible to potentially apply for a partner visa while you're onshore. Okay. Now, if there's a situation where you lost your substantive visa because you're an AAT or you just hold a bridge visa A while onshore, usually, and you want to apply for a partner visa and you're still onshore. With a partner visa, if you don't hold a substantive visa, the usual thing is you must apply only offshore for a partner visa. Now, the only way to get around this while you're onshore, when you're holding a bridging visa A and you want to apply for a partner visa, is that it has to be compelling, compassionate grounds. Only that. And there's very limited circumstances where you can prove that you have compelling, compassionate grounds. I'll just give you a hint. If you're heavily pregnant and you're about to give birth, you have a baby with an Australian citizen, you may be able to satisfy that requirement, but it depends on circumstances. But I don't want to encourage you to think this way. But for you to understand, it's very limited circumstances that you're able to lodge a partner visa while you're onshore if you do not hold a substantive visa.
He's on 485 visa.
Yeah, so you hold a substantive visa, 485. Now, if I can help you further, if you're intending to apply for a partner visa, just note this. You just can't just apply for a partner visa without knowing the full gist of it. Either you're in a de facto relationship of at least 12 months before you can lodge the partner visa, or you do get married and you have a marriage certificate to show for it. Now, let's talk about the marriage certificate. You can't just go off and decide to get married tomorrow and you'll get the marriage certificate. It takes time. One of the steps that you need to think about is you'll be delayed 1 month at least, because before you get married, and get a marriage certificate, you need to apply with the intention to get married, and that you have to go to the marriage registry and you lodge an application. They'll make you wait 1 full month. So please keep that in mind. Once you've satisfied that 1 month of wait, then you can go and get a celebrant to marry you. They'll give you a marriage certificate. It usually looks like a yellow piece of paper. Congratulations, you're married. But that marriage certificate does not stand in the eyes of immigration unless you get it registered through the birth death marriage registry. So you have to go and get it registered. It could take 1 to 2 weeks before you get that registered marriage certificate in your letterbox. And so once you have that in your possession, then you'll be eligible to apply for your partner visa. In terms of the de facto relationship, you need to know that you can't say that you're in a boyfriend-girlfriend situation and then you want to go and apply for a partner visa. First of all, you're on a student visa. when you first come over to Australia to study, your status is single. You know, you've never been married before. And then you end up, developing a relationship with your boyfriend or girlfriend. Even if you have been together for 2 or 3 years even, but if you haven't notified immigration of your change of status from being single to being in a de facto relationship or even to get married with them, then on immigration records, you're still considered to be single. So before you do anything, you need to change your circumstance. So you need to advise immigration that you're no longer single. So you need to email to them and fill in a form 1022, change your circumstances, and update immigration of your change of status from single to married or in a de facto relationship. And even with the essence of being in a de facto relationship, you need to prove that. And how to prove that? You need to backdate 12 months before. So let's say you want to apply for a partner visa next month. Then next month is in October. You should need to show that you've moved in together since October 2018. So anything, the general gist is, joint bank account statements need to have been opened since October 2018. Joint lease agreement, joint utility bills, everything has to be backdated at least 1 year before. Hopefully you understand the gist of it, okay? And that's the only way to be safely, to show proof, evidentiary documents, evidentiary proof that you are in a de facto relationship. And if you cannot show enough evidentiary documents, then you will surely fail when you launch a partner visa, okay?
Another question is from Mohammed Imran. Hi, is there any chance after refusal of AAT someone apply for FCC and FCC does not accept to take the appeal? If this is the case, what would be the possible reason?
In terms of the FCC, I'm not going to go to too much detail, but when you decide that you want to further appeal to the higher court because you failed the AAT, you are not stopped from appealing. It's open to anybody who wants to continue to appeal, so you're not stopped there. But to be successful, to win at the AAT, you need to consider that there must be some jurisdictional error that has been made by either Immigration Department or the tribunal, the AAT tribunal, for FCC to consider your merits review application for you to be successful at the federal court. So it must be something that's an error in law that's been made along the way. If not, you will not be successful at the FCC, okay?
Another question is from Vanessa again. She's asking, I got my AAT at the moment and got my son, and his next year is about to go to school. Are we allowed to enroll him? My son is born here, but we are onshore AAT at the moment. Can my son enroll on upcoming school year?
Well, is it, I suppose, if you, it's a student visa or 485, you'll still be at the international student rates anyway. So yeah, the son can still go. If you hold a bridging visa, and you can still let your son go and study. Yes, of course.
Okay. There's one question that's related to 189 invitation, asking, do you think 189 invites will be increased from September round, or will it remain at 100 till June 2020? Which we cannot predict that. Yeah, we cannot predict that for you.
Yeah.
But at the moment, that's all the questions that I have
Great.
here. Yeah.
Okay. So so I wish you all a great afternoon, and if you need any advice, please do remember Aussizz Group, especially Aussizz Group in Perth. If you're in Perth, please come down whenever you have any queries. We're here to help you along the way on your journey.